that would give your client the right to sell this property, and Ms. Hornig would give your clients the right to say, wait a second, you threw a lot of our good stuff out on the street, for lack of a better word, and whatever that means, because I'm not hearing that there's necessarily an objection to the sale, just that you want to protect that property right of your personal property, your client's personal property. And to me, that, if nothing more, at least let's stop one part of the issue here, and we can address, or the state court can address the personal property issue either by way of motion or adversary proceeding, however you want to go forward on it. In that way, it seems to me that the debtors can get all their evidence together. I mean, we've got a statement by counsel and by Ms. Sweet that there's nothing more there. So, I mean, even if I were to say, okay, everyone get in your car and meet at 5 o'clock at this house and pull everything out, there's nothing to pull out. So we have to live with that unless something miraculously appears again. So that's what I'm thinking, is let's have an order that allows for the sale with the understanding that 362 doesn't apply to the sale, but preserve all your rights to make claims for the value or conversion or whatever the case may be, either here or in another court. Ms. Hornig, does that cover your client's concerns here today? And there'd be no issue that the personal property has been abandoned. That would be what I would see as the other issue that you're concerned about.
Yes, Your Honor.
How did you want to address that? The abandonment issue for personal property, Your Honor?
Right. What I'm saying is that this order doesn't really address that issue whatsoever, and it preserves whatever rights you would have in this property, and they may be everything or they may be nothing. I'm not in a position to tell you that today because I don't have any proofs, but it certainly protects you as much as you can possibly protect today. Again, if the proofs were, if there's evidence that, you know, you still had your TV and the couch and a few things left there, I'd say, like I said, everyone get there at 5 o'clock with a truck to move this and let's move. But we can't do that because apparently it's not there anymore. So now we have to deal with what's the value of that one way or another. And we either do it in this court at a later date or you do it in another court in a later date. That's what I'm thinking right now, because you wouldn't know really what the value of some of your property is until you maybe, one, thought about what was there, and two, how much did it cost, and how much did it cost to replace it. So there's an advantage for everybody, it seems to me, in that situation. So does that answer your question, sir?
So long as it's not deemed abandoned by the court, I guess it would be my biggest concern, because they're operating under the pretense that this document...
That's exactly the purpose of the language.
And Mr. Havens, that's exactly what you're proposing. Just let this real property be sold without any further ado, right?
Well, with one condition, Judge. If you ended up having to be a visiting judge down in Detroit, I'm sorry, Flint is as far south as I go.
I see. Now, by the way, the record should reflect we have this scheduled in Flint because of the time constraints, I think, both of the sale. And Ms. Hornig, I think you were going to go on vacation or away for a few days, and so we put it here in Flint today. Future hearings would be held in Bay City unless there's something that I don't know about.
Well, I don't know, Ms. Honig and I might get together and put you up in a room at the Soaring Eagle, and maybe we could find one of the courtrooms at the local court here for you.
Not too sure we're authorized to do that.
Can I ask a question?
Sure.
This form that Bruce filed, it actually gave his client permission, or says the intent to go in and take our stuff, and that's what she did. It was there. I mean, we'd be sitting here today saying we have stuff in the house to remove if she hadn't gone with what her attorney created. So, but I'm sitting here today saying that it's kind of being ignored that they took this stuff with this form and just were having an order until a later date. Meanwhile, who knows what she's doing with our stuff, so in the end, it may not even be there. I mean, we wait another 2 or 3 weeks, she could be selling it, giving more of it away. I mean, I guess that we got to this point because of here and now it's becoming another issue. You know, Leslie said the bankruptcy was, they knew the bankruptcy from the beginning. It was her other attorney, Nancy Gallagher, who canceled our motion to set aside the default. You know, I just feel like it's, you know, they kind of played in here, did a 7, didn't give us the right time to remove our possessions. And yeah, they want possession to sell the house, but I feel like we're still getting kind of robbed from our stuff when he even admitted that he kind of went a weird way to make it happen fast, but in that weird way, he didn't notify us that we only had 7 days to get our stuff out. And now the stuff is gone, and now the court's telling me that we need to wait and handle it a different way. But he handled it this way.
Right.
I guess that's my confusion. I mean, I understand what you're trying to protect us, but I'm also feeling that he kind of went a quirky way, and now that piece of it's not going to matter today.
Well, see, how I kind of looked at this case, ma'am, is that on one hand, you had a lease for this property on Walton, and it appears that that lease didn't work out well for whoever, and that you had to leave the property. And second, the Ms. Sweet, who owns the property, has someone who can buy it, and we would have the sale on that. Now, that's one half of the coin. The other half, or the other side of the coin, is your personal property. And that, there's two issues here. First off, procedurally, it's not particularly well in front of me, because I think what Mr. Haven wanted to do was, and your attorney, Ms. Honig, out of an abundance of caution, protected you on this front. I think Mr. Haven just wanted to have it clear that the real estate could be sold, was not part of the bankruptcy estate. Ms. Honig did an excellent job of making sure that I know that there's also more to the story than just that, and that part of the story is your personal property and what happened to it. Because, as Mr. Havens has said, the bankruptcy was filed on August 10, and it looks like the complaint to evict wasn't filed until afterwards, and certainly the hearing on September 7th occurred after August 10. I mean, those are all facts that no one can argue about. And then the issue is that if you had things there that are no longer there, then someone needs to explain what happened to it. Now, from your standpoint, you've mentioned to me some, I think it was like a sofa, love seat, TV, other items, but I remember those three very clearly. That would strike me to be worth a fair amount of money. Now, the Ms. Sweet would perhaps take a different view of that, and that's why I don't know what was there and what wasn't there. I do know from what's been told by everybody that there's nothing there now. And if the Ms. Sweet or someone under her control took that stuff, for lack of a better word, converted it, well, then she has to explain that to some judge sooner or later. And you want to be in a position to say, this is the laundry list of things that were there, this is how much I paid for it, this is how much it's going to cost me to replace them, and that's what we call damages here. And that's what I'm trying to figure out is, what can we take care of immediately but still protect everybody else? Because at the end of the day, if you don't have an interest in the real estate, there's no reason not to sell it, if nothing more than to let Ms. Sweet have the money that she may need later on, and now I'm going to speak from your standpoint, to pay you some money, and that's what you'd want to have her have. So that's what I'm looking at here. It's going to be up to you and Ms. Honig to decide when do you want to bring that to the court's attention, how do you want to bring it to the court's attention. There are different ways of doing that. And I'm trying to make sure that whatever rights you have today in this property they aren't being adversely affected by that. So Mr. Havens, first off, before I say anything more, ma'am, does that answer your question a little bit clearer? Do you understand, Translator?
Yes.
Mr. Havens, can you put together an order that, one, allows for the sale of this property, indicates that Section 362 is not applicable, and finally, however, that the court reserves for the debtors all rights that they may have as to the personal property, and that it's not deemed abandoned, at least for purposes of today?
Yes, sir.
And Ms. Honig, you'll want to take a look at this order?
Yes, Your Honor.
Right. When do you leave? Because I remember we had...
I actually leave Friday, but I had court tomorrow afternoon. That's why I can be in Bay City tomorrow afternoon.
I see. That was the problem. I remember there was a schedule issue. So, Mr. Havens, can you get that order over to Ms. Honig as soon as possible, because she should take a look at this order before.
Yeah, I'll call my office before I leave here, and we'll have